information, we have three basic legal bases. The bilateral treaties in the first place, as I said, Article 26 of the OECD Model Tax Convention is our legal basis. Multilateral Convention on Mutual Administrative Assistance in Tax Matters, the MAC, itself is basically, it allows many different sides of exchange of information and sort of cooperation, different ways of cooperations it involves. For Turkey, it is at the Grand National Assembly of the Parliament for the time being, but not ratified yet. And in the exchange of information, we have three basic legal bases. The bilateral treaties in the first place, as I said, Article 26 of the OECD Model Tax Convention is our legal basis. Multilateral Convention on Mutual Administrative Assistance in Tax Matters, the MAC, itself is basically, it allows many different sides of exchange of information and sort of cooperation, different ways of cooperations it involves. For Turkey, it is at the Grand National Assembly of the Parliament for the time being, but not ratified yet. And also we have tax information exchange agreements with some countries. Now, we have double taxation conventions with 90 jurisdictions, and 83 out of these 90 are in place for the time being. And tax information exchange agreements, we have 5, and 2 out of these 5 are in place. And all these agreements have the TIAs also, they are all, specifically about the exchange information, but double taxation agreements, all of these agreements have the exchange of information article on that. Basically, double tax convention involves 3 main types of information exchange. Mostly we implement the exchange of information on request, and which basically, as I've told at the beginning, we collect information from the taxpayer and from other sources and send this information to the other jurisdiction. And of course, I will a bit elaborate about how the confidentiality and data safeguards are secured in these agreements. Spontaneous exchange of information is when a jurisdiction considers that these information will be useful for the other jurisdiction, then it provides this information to the other one. Automatic exchange of information, the new fact of our lives, is again the collecting information from the taxpayer and submitting them to the designated jurisdictions periodically and automatically. And I just would like to mention that, I will be coming there, but both the single double taxation agreements involves this automatic exchange of information method, and also the MAC itself is its legal basis. Confidentiality is sort of secured through the Model Tax Convention as well. The article itself starts like this. Just let me tell you. The competent authorities of the contracting states shall exchange such information as is foreseeably relevant for carrying out the provisions of this convention or to the administration or enforcement of the domestic laws concerning taxes of every kind and description imposed on behalf of the contracting states or of their political subdivisions or local authorities insofar as the taxation thereunder is not contrary to the convention, etc. So it says shall, and it's sort of binding for the signing country to change the information. But then afterwards, in what circumstances there are exceptions of this for data safeguard reasons, trade secrets, etc. And paragraph 2 sets the main rules and the provisions for the data safeguards and confidentiality. First of all, it is important that the received information should be treated as obtained under the domestic laws. So that's why this would allow us to protect the information with, received with the Tax Procedures Law, Article 5 of Turkey. First of all, confidentiality has to do with both the provided and the received information. And as I've said, both the treaty provisions and domestic laws apply to ensure confidentiality and limits the disclosure of that data. And as I've told you that we are quite sensitive about the received information and all these procedures and to send and submit the data to the other parties. To which parties we can disclose this information according to the double tax agreement, that certain specified persons or authorities, courts, administrative bodies, and third countries, if allows it, and only if the other party allows that to use this information for other purposes than the taxation, then it can be. This provision should be in the double taxation agreement, and for the time being, as far as I know, only 2 out of these 90 double taxation agreements has this provision that which allows the other party to use information for other purposes, provided that the other one allows this. And afterwards, our domestic legal framework comes. Article 20 of the Constitution provides the basic protection for the personal data at the constitutional level, but it's sort of like has a phrase as well that personal data can be processed only in cases envisaged by law or by the individual's own consent. And afterwards, what the most important in taxation area of Turkey about the data confidentiality and data safeguards is tax, as I said, Turkish Tax Procedures Law, Article 5. According to the Article 5 of our tax procedure law, it reads, officials in charge of taxation, formalities and examination, officials in tax courts, district administrative courts, those assigned by the State Council, those taking part in the work of commissions instituted in accordance with fiscal laws, experts employed in taxation operations, are bound by a duty of confidentiality, which explicitly applies to the international exchange of information implementations as well. And it follows like this. They can neither divulge nor use for their own benefit or for the benefit of third persons the secrets with which they have become acquainted during the performance of their duties regarding the taxpayer or those in relation with him, the situation of their accounts and transactions, their business, undertaking, wealth or profession, or other particular information which must remain secret. This prohibition continues even after the aforesaid persons have retired from these duties. And domestic legislation, we have also some other provisions, but this is the main legal basis for confidentiality and data safeguards. It just has to do with both the international and domestic information as well. And Article 152 of this law reads, the information gathered by tax administration must be kept confidential in the information records. But what more? What if sort of someone breaches this confidentiality? Then again, the same law explaining what happens is Article 362 is, if those who are liable to comply with the confidentiality of taxes mentioned in the law infringe this confidentiality, they will be punished according to the provisions of Article 239 of Turkish Criminal Code. So that's why any breach of this confidentiality has been punished and strictly and powerfully sort of legislated by this way. And then the Turkish Criminal Code sets the punishments of that, etc. And at the administrative level, again, any breach, any public servants who disclose confidential information will be forbidden from being promoted for 1 to 3 years, is sort of considering the fact that the promotions are automatic. It happens in Turkey that this is a relatively heavy sanction as well. These are the very basic legal basis for us, on what basis we protect the confidentiality during this process. And of course, we have sort of data protection law, or individual data protection law, and it recognizes when the processing or transmission of the data is provided in other laws. It recognizes an exception of that protection when there is some provisions in other laws which allows to share the data. In implementation, how we implement this exchange of information. Just let me start from the very beginning, because according to the commentary of the OECD Double Taxation Convention, it reads like even the letter requesting the information which triggers the whole process itself is confidential. And the whole process afterwards should be sort of treated with confidentiality. So we are also, just acting according to these provisions. And in that way, sensitivity quite much matters, and we are dealing with that. First of all, in order to, empower the confidentiality, we perform the exchange of information mainly in the paper form, rather than exchanging all the data through emails, etc., or some other stuff. We use the paper form. Sometimes we need the encrypted CD-ROMs if the information exchanged involves quite much data. And after, just when we receive this, we sort of like seal all the documents, highlighting the confidentiality of that information. And basically, we are receiving the information for the use of tax inspection board, for the tax auditors, and after processing it here, and we are sending this information for the audit purposes. And all these processes are again conducted with confidentiality. As I've said, in Turkish we have here, which is highlighting the tax procedure law, Article 5, and the other articles of the legislation, and how the breachers will be sort of punished according to which article. And again, just the sensitivity is very important, and both the information, when we receive information, we highlight this confidentiality. I will be getting a bit of details about the more implementation and the other sides of the issue. We treat highly sensitively to this data and highlight all the levels of this confidentiality. Another aspects of the issue, when again we receive sort of an information from an auditor, and before sending this, we process the information, of course, and seal all the documents. Of course, the letter itself involves all the limitations of the use of the data, how the confidential is, etc. And also we highlight this phrase. This information is furnished under the provisions of the double taxation agreement in force between our countries, and its use and disclosure should be governed in accordance with the provisions of that agreement. So again, we are doing this. And another security measures, you know, we can be in our own unit, we are quite sensitive about it, but there, you know, we have a database, the IT center, etc. How we sort of like secure the confidentiality? First of all the staff and contractors can access to the premises with secure ID cards, and all the access to the premises have been recorded, electronically recorded. It's very important. Without that secure ID cards, no one can access to the buildings. At the unit itself, we are having all the documents and the information in lockable cabinets that then we process the data, views on this, and lock that cabinets afterwards. At the Turkish Revenue Administration, we have a clean screen policy, you know, which reads something like, if any computer, no one used that computer for 10 minutes, for instance, it's automatically locked. After 11 p.m., all the computers have automatically been locked. And we have all the password systems, you know, and secure access to the IT system, etc. And we have also sort of like a model based on the level at the authority, you know, and you can only access to information according to the level you're at the administration. And we have high levels, firewalls and security systems, and all of these from legislation basis to the implementation side, IT security, have been sort of like screened by the OECD, and both in 2013 and 2016. I will tell a bit about that. That both the legislation side and the implementation side, the IT security side, etc., are quite compatible with the data safeguards and confidentiality standards of the OECD. And again, I was told that segmentation of the authority to access Turkish Revenue Administration database. And there are another one thinking about the hiring process itself has some security sort of checks, etc. And the trainings of the personnel at the beginning highlights quite much about how the security and data safeguard is important in our business, and all the links between tax procedure law, Article 5, and these issues have been sort of underlined during that trainings. Before finalizing, I would just like to mention that for exchange of information on request, in 2013, we had a peer review process. And during that process, peer review group members visited our country. They do for almost 140 countries, by the way, not specifically for Turkey, but within some time limits, they do it in every global forum member jurisdiction. As of 2013, again, about exchange of information on request, we received a report that our confidentiality and data safeguards measures are quite much compatible with the OECD, and we didn't receive any complaint about that. And last year, a year ago, another screening process we received, again from the Global Forum of the OECD, and this time it was about whether we are ready regarding the confidentiality and safeguard measures on automatic exchange of information, the CRS Common Reporting Standard, and it was found out that we are again highly compatible with the OECD standards, from legislation to implementation to IT side. Again, all this stuff I mentioned, we are in a very good position in this sense as well. So we didn't receive any complaint about that, and we didn't receive sort of any problem with that. So in that sense, it was, I can mention that it was a bit of certified. Why this is important? The last year, the OECD published, because before the partners list is created, you check the countries, you know, and you check these reports whether the country you will be sharing information is compatible with these data safeguard and confidentiality rules. If they are not compatible, you simply don't receive their request for automatic exchange of information. Thank you so much.